Folks, if you guys want to just keep talking, that's fine. I'll leave. If you're saying to me that this was filed because he was in possession of the premises, then I would need to have a notice to quit. I don't have a notice to quit in the file. The complaint that's filed in this matter indicates that the defendant was basically served a notice to quit.
He was never.
Folks, if you guys want to just keep talking, that's fine. I'll leave. You guys are just going to want to fight about everything. Court does call the case of the Park at Sagebrush versus Marissa Escobedo.
Good morning, Your Honor. Gail Rosen on behalf of Ms. Escobedo.
All right. And I also say Christopher Cook. Ms. Lacey, I think you're muted.
Sorry, Your Honor. Gabriel Lacey for Park at Sagebrush.
All right. This is a non-payment of rent case. What is plaintiff's claim?
Thank you, Your Honor. At this time, the outstanding rent to retain possession is $4,095.71. Court cost of $232. Total outstanding balance is $4,327.71.
All right. Ms. Rosen, you don't represent Mr. Cook or Cook.
I do not, Your Honor.
All right, very good. All right, so go ahead. What do we want to do with this?
Well, if I may, Ms. Escobedo has rent for March. The reason she's delayed in paying that is she had tried to pay it earlier in February because she has 4 children. She had to take to Washington State for a court-ordered visit with their father. She was not allowed to pay it earlier. She's tried to pay it since and has asked that they waive the late fee and won't. So she can pay that on Monday if the late fee is waived. As far as April rent, she's submitted an application for state emergency relief. So she's asking for some time to pay.
Got it. So how much is her monthly rent? Yes.
I believe her monthly rent is $1,804.
So this is what I'm looking at basically is 2 months plus what may be some ancillary charges.
That's my understanding.
Okay. So is it that plaintiff won't take the February rent or she doesn't want to pay it without them waiving the late fees?
It's the rent for March, and yes, she's ready.
March.
She's ready to pay it if the $50 late fee will be waived. And then, as I indicated, for April's rent, she needs more time for the emergency relief to process.
All right. And here's what I'll do. I'll adjourn this out to the 18th. I don't have a full docket on the 11th. So I'll adjourn this out to April 18th, 2025 at 12 p.m. That's an in-person hearing. Ms. Lacey, you can talk with your client about waiving that fee and see what you guys can come up with. I mean, if she's got the money, let's try to get it paid. All right.
And Attorney Rosen, if you want to reach out to me in the meantime, so we can try to negotiate something.
Absolutely. Yep. I will reach out to you later today.
Awesome.
And if she's done the SCR, we would need to have the rental assistance form to the court by Wednesday.
This Wednesday.
Tracking.
Okay.
Yes. All right.
I will get that to the court. Thank you so much, Your Honor.
Thank you.
Have a good morning.
You do the same.
Judge Simpson is doing more than simply giving the tenant extra time. He is separating the undisputed March rent from the still pending April assistance request and pushing both sides toward a practical resolution. The defense says the tenant already has March rent available, but wants a $50 late fee waived. Legally, that fee dispute does not erase the underlying rent obligation, so withholding the entire payment over a relatively small charge could weaken her position if negotiations fail. At the same time, the emergency relief application may create a realistic path to curing April's balance, which explains why the judge requires the rental assistance paperwork before the next hearing. Notice how he does not order the landlord to waive the fee. He encourages counsel to negotiate, That preserves the landlord's contractual position while signaling that accepting available rent may be more sensible than escalating the eviction. Do you think refusing the full March payment over $50 was a smart bargaining strategy? The next hearing will likely turn on whether payment is made, whether assistance is documented, and whether the parties use this adjournment productively.
Westridge Mobile Home Park versus Michael Troon.
Gabriel Lacey for Westridge, Your Honor.
Michael Troon, not checked in. You paid for second service. If you'd raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Thank you, Your Honor. At this time, we would motion the court for a default judgment for possession only, where the outstanding rent to retain possession is $1,297.62. Court cost of $183. Total outstanding balance is $1,480.62. We are asking for a pay or vacate date of April 14th, 2025. And I do a test. Hold on, Your Honor. I'm sorry. I think I read the wrong numbers.
Okay.
We're on C1071, Your Honor.
1071. Yes, ma'am.
Okay, yeah, I read the wrong numbers. Strike that, Your Honor.
Okay. All right.
The rent to retain possession for 1071, Michael Troon, Your Honor, is $1,620.97 for a cost of $183. Total outstanding balance is $1,803.97. We're asking for a pay or vacate date of April 14th, 2025. And I do attest to the best of my knowledge and belief that Mr. Truhan is over the age of 18, a competent adult, not deployed on active duty in the military, and that we have kept the unit fit for habitability.
All right. Judgment to the plaintiff. That is by default for possession, redemption amount, any amount requested with a writ issue in 10 days. Westridge Mobile Home Park versus Johnny Lewis.
Gabriel Lacey for Westridge.
Johnny Lewis, not checked in. You may proceed.
Thank you, Your Honor. At this time, we will be requesting a default judgment for possession only, where the outstanding rent to retain possession is $1,297.62. Court cost of $183. Total outstanding balance is $1,480.62. We are asking for a pay or vacate date of April 14th, 2025. And I do attest to the best of my knowledge and belief the defendant is over the age of 18, a competent adult, not deployed on active duty in the military, and that we have kept the unit fit for habitability.
Judgment to the plaintiff. That is by default for possession, redemption amount, any amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Court does call the case of Societa Management versus Ricky Noble.
Gabriel Lacey for Societa Management.
Ricky Noble, they are not present. You may proceed.
Thank you, Your Honor. At this time, I believe had a note on this file, Your Honor. I do not believe that service was perfected on this file, Your Honor. And so we are asking.
I have. Oh, yeah, they filled in. Okay. They have no service made.
So if we could just adjourn today's hearing so that we can perfect service.
Got it. Adjourn the matter to April 18th, 2025 at 12. Well, yes, at 12 p.m. Well, no, we wouldn't do that if I'm adjourning for service. It's going to be a first hearing. Do you know what time?
Yes, I'm sorry. Let me open the appropriate docket.
Okay. 18th at 10 a.m. That will be by Zoom.
Thank you, Your Honor.
All right. Thank you.
I believe that's all for me. Have a wonderful day. Go Tigers.
All right. Yes, indeed. Take care. Arbor Knoll versus, these are all theirs.
Yes.
Okay. Arbor Knoll versus Brendan Henry. Westridge Mobile Home Park versus Marie Ward. Westridge versus Hazley Uceda versus Malakia Beverly. versus Jose Amaya versus Thomas Kearney, Park at Sagebrush versus Thomas Kearney, and Celine Mobile Home Park versus Joshua Everly. Those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you. Valley Ranch versus Brandon Kuchar. And also Carolyn, is it Migda?
Migda, she is not present though, but Brandon Kutcher here.
All right.
Sorry, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
All right. And what is plaintiff's claim in this case?
Your Honor, I have rent to retain of $4,263.49, cost of $182.00, for a total of $4,445.49.
Okay, Mr. Kuchar, what do you have to say about that? How are you intending on getting this paid?
She's not here, but I was hoping to have this adjourned to the 11th or the 18th, whatever fits your schedule, and we'll have payment made in full on or before the 11th. So I guess by the 10th, so that it's in there before we were to meet again.
All right. My next date that I really have a docket that I can do on this will be the 18th. I'll grant you an adjournment to the 18th, 2025 at 2 p.m. Escrow,
2 p.m.
given that adjournment is reserved. Yes, 2 p.m. That's in person. If it's paid, check with the attorney's office. They may just dismiss the case out.
Okay, thank you so much, Your Honor. Thank you, Ms. Matson. Have a great day.
Thank you, Your Honor.
Thank you. Spice Tree Apartments versus Samuel Bishop.
Casey Matson on behalf of the plaintiff.
Samuel Bishop. There is no response. If you'd like to take a default, raise your right hand. Do you solemnly swear a firm testimony you're about to give will be the truth,
I'm
whole
here,
truth,
Your Honor.
nothing but the truth, so help you God? Hold on. Dial in. Your name, sir?
Samuel Bishop.
Okay, he's here. All right, he said dial in. All right, what is plaintiff's claim in this case?
Your Honor, I have rent to retain of $2,485.62, cost of $189.00, for a total of $2,674.62.
All right. Mr. Bishop, how are you intending on getting that paid?
Yes, I plan to have it paid in full around the 18th. I had my wallet stolen from our complex parking lot last weekend, and it kind of threw my plans in disarray.
What I will do is I'll reserve escrow at this point. I'll adjourn to my next available date, which is the 18th, April 18th, 2025 at 2 p.m. That's an in-person hearing, sir. If you have it paid before that point in time, you need to contact the attorney's office, make sure they may dismiss the case, but everything would need to be paid. Understood?
Understood.
All right. Thank you.
Thank you, Your Honor.
Court calls the case of Spice Tree Apartments versus Cameron Hall and Latwana Mitchell.
Casey Matson on behalf of the plaintiff.
Hello, do I have Cameron Hall? Yep, looks like I do. Hello, I can't hear you, I don't think.
Oh, hello.
Hello, what's your name?
Cameron Hall.
All right, very good. What is plaintiff's claim in this case?
Your Honor, I have rent to retain of $3,096.40, court costs of $182.00, for a total of $3,278.40.
And Ms. Hall, how are you intending on getting that paid?
I have no idea.
Okay, have you applied for any assistance?
No.
All right. Would you like an opportunity to do that?
Yeah.
Okay. Did you see the video that played before the hearing, advising you of different resources?
Yes, I did.
All right. I'm going to suggest that you contact Hawk, HAWC. And did you get that phone number?
No, could you provide me with the phone number, please? Sorry.
961 1999.
Thank you.
All right. Do that. And why don't I do this, Ms. Hall? Well, let me ask this. Is there anything that you can pay between now and the 18th?
I could pay something, but it probably wouldn't be a lot.
Okay. How much do you think you can pay?
Probably anywhere between 300 to 500.
300 to 500?
Yes.
All right. I'll put in the file 300 to 500. When would you be able to make that payment?
By the 18th.
By the 18th? Okay, you'll have to pay it by the 18th prior to the hearing time. So I'll adjourn this then to the 18th, 2025 at 2 p.m. That's an in-person hearing. Okay?
Okay, thank you.
All right. And what I'm going to do is I'm going to put you into a breakout room with our court liaison officer, Amy, that you speak to her about resources that might be available to you. Okay?
Okay, thank you.
All right. Thank you. So hold on the line. Good morning, Amy.
Good morning, Your Honor.
Your Honor, is she paying that into escrow or just directly to my client?
I I'm not sure. Send a message that she's to pay the funds directly to the landlord. All right.
Thank
All
you.
right. You're welcome. All right. Whitaker Oaks versus Gene Zimmerman.
Casey Matson on behalf of the plaintiff.
Gene Zimmerman. All right. Now you can raise your right hand. We can go with that oath. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right. Go ahead.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $1,625.43. Court costs of $200 for a total of $1,825.43. Writ to issue in 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Whitaker Oaks versus Randy Widener. Widener, they're not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $1,671.59. Court cost of $239.00 for a total of $1,910.59. Writ to issue in 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Whitaker Oaks versus Marjani Green.
Casey Matson on behalf of the plaintiff.
And Daniel Keener. And Miss Green's here. Hello.
Good morning.
All right. How much is owing on this?
Your Honor, I have total rent to retain of $2,440.16. Cost of $239.00 for a total of $2,679.16.
Miss Green, how are you intending on getting this paid?
I have an prevention appointment with Hawk scheduled for April 18th. They said that they would assist me with the balance.
Okay, you have an appointment with Hawk?
Yes.
That's on the 18th?
I mean, I'm sorry, not the 18th, the 16th.
Oh, you have it on the 16th. Okay.
Yeah.
So what I'll do on this matter, have that on the 16th. I'll reserve escrow in this matter. I will adjourn this case out to April 18th, 2025 at 2 p.m. That's an in-person hearing.
Okay.
And then we'll see exactly where you are with Hawk, since you're
Okay.
particularly you're under the 3,000 mark. It looks promising. Okay.
All right. Thank you, Judge.
Thank you. Whitaker Oaks versus Kristen Davis.
Casey Matson on behalf of the plaintiff.
I'm here.
Okay, what's your name?
Christian Davis.
All right. All right. What's the claim in this case?
Your Honor, I have rent to retain of $1,918.16, cost of $200 for a total of $2,118.16.
Sir, how are you intending on getting that paid?
I have the money. It was just a issue with my payments not going through because of something not updating the DTE and not getting the DTE payment. I guess just the rent couldn't get processed, so I should be able to have it by the 18th.
Okay, is there anything you can pay before the 18th?
Yeah, I should be able to pay it in full as soon as possible.
Okay, so what day can you pay it in full?
Friday payday.
The 11th?
Yes.
All right, I'm going to mark the file that you're going to pay the balance by the 11th.
Okay. They she said, the lady at the office said something about, I just talked to her yesterday. She said to come up there and it's just a few things that she needs me to do, and then I guess she'll lift the eviction notice or something.
Well, what will happen is that if you pay it in full, I'm sure they'll contact their attorneys to dismiss the case.
Okay, got you.
Other than that, I don't know what she could be talking about.
Right.
But I'm going to
okay.
put in here, you're going to pay the balance by the 11th. I'm going to indicate that escrow is reserved. I will adjourn the hearing out for April 18th to April 18th, 2025 at 2 p.m. If the balance isn't paid, you'll need to appear in person, sir.
Okay, April 18th.
Yep, 2 p.m.
11.
All right.
All right, thank you.
Okay.
Appreciate it, Your Honor.
Thank you.
All right, bye-bye.
Sylvan Crossing versus Aria Cummings Jones.
Casey Matson on behalf of the plaintiff.
Cummings Jones, they're not checked in. You may proceed.
Thank you, Your Honor. I have rent to retain of $884.33, cost of $194.00, for a total of $1,078.33. Would be requesting entry of a default possession only judgment, writ to issue in 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Sylvan Crossing versus Andre Marshall.
Casey Matson on behalf of the plaintiff.
Andre Marshall, not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $2,153.33. Cost of $194.00, for a total of $2,347.33. Writ to issue in 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days.
Thank you, Your Honor.
Thank you. Have a great weekend.
You as well.
Court does call the case of Wayne Docket versus Dennis Heyman.
Good morning, Your Honor. Stacy Denzer appearing with and on behalf of Wayne Docket. We're appearing by Zoom.
All right.
Good morning, Your Honor. Kimberly Hammond appearing on behalf of Dennis Hammond.
All right. And it's a non-payment of rent case. Plaintiff, how much is claimed owing?
The same 4,500 that's owed by the other tenant. It's a joint and several liability, so we're trying to get it from one or the other.
Okay, so $4,500.
Yes, sir.
All right.
Your Honor, we've disputed the charges on a number of bases, filed a counterclaim and answer affirmative defenses, a jury demand. And so I saw the last proceeding, even though I was not notified of it. I also tried to look up the case that was cited in C2 of the complaint, which it doesn't exist. Never received a notice to quit. I received something from Attorney Dinser the other day, which looked like a notice to quit that said it was personally served. It was never personally served. So he never received a notice to quit. I believe, Your Honor, they're trying to double dip, and they've never really even formally evicted this person.
Well, he's moved out on his own. He's no longer there.
Do you have a written statement from him or anything that says that?
Nothing of his is there. The apartment is empty, and he's gone.
And how do you know?
So Mr. Heyman is gone?
Because I've been in the apartment.
Okay.
Mr. Heyman's gone?
Yes. That's why we didn't sue for possession on that one.
He didn't know about any of these proceedings until he got this complaint. Via first-class mail, I might add, from your court. And apparently it's for money damages, which he should have been personally served.
I did serve him personally.
Where at?
The courthouse.
I don't have.
You served him at the courthouse?
Folks.
Yes, he wasn't forced to.
I don't have any indication or marking in my file of service. First
I
of
mailed
all,
it in, Your Honor, and the mail is really horrible. I've mailed it to the courthouse.
all right. Well, all I'm going to tell you,
He
I
wasn't
don't
at the
have it.
courthouse.
So
I mailed it to the courthouse.
I think she's saying that she mailed the proof of service to the court.
Yeah, but I know he wasn't at the courthouse. I know he wasn't.
He was. I saw him. I handed it to him.
On what day?
The day that Bria was there. The day we were there with Bria.
Hey, folks, I'm not going to sit here and listen to this. You guys can either figure out how to argue this out or whatever. But the issue is not possession, correct?
Correct.
Or counsel, are you aware of that or what?
I was not aware of that, no.
Well, the complaint's for money only, not possession. Because he's already out. The apartment's empty.
Well, then my question would be, why wouldn't this be a GC case?
My question as well.
Well, because he's owed the money on the landlord-tenant. He's owed the rent. So they're jointly and severally liable. I'm not trying to double dip. I'm going after both people on a joint and several lease. If whatever I get from Rhea,
All right.
we would take off of what's owed by.
So if somebody would mind answering my question, it'd be nice.
Should be plaintiff.
Why wasn't this filed as a general civil action as opposed to a landlord-tenant case?
Because the money is owed under the lease. So I just filed it under landlord-tenant. I originally had gone after both of them. Actually, Jason Negri was supposed to go after both of the occupants of that apartment at the same time. And his complaint said Rhea and all other occupants. And he was under the impression, I guess, that covered Mr. Hammond. And I don't believe it did. So I filed a separate one for Mr. Hammond.
All right.
And
But I
agree
think
with you, Your
but
Honor.
then I think it should be a GC case. This is not a landlord-tenant case.
I can
If
file,
the
I can
property-
refile it
if-
as I can refile it as a GC, Your Honor. I'm happy to do that.
This is
All
the
right,
central
well-
procedural problem in the case. The plaintiff is trying to recover money through a landlord-tenant filing, even though possession may already have been surrendered. Summary landlord-tenant proceedings are designed primarily to resolve possession quickly. Once the defendant is no longer occupying the property and the dispute is only about unpaid rent, Judge Simpson questions whether the claim belongs in a general civil case instead. That distinction matters because the filing requirements, service questions, defenses, counterclaims, and available procedures may differ. The plaintiff argues that joint and several liability under the lease allows recovery from either tenant, and that may support the debt claim, but it does not automatically answer whether this is the correct procedural vehicle. The defense also attacks notice, personal service, and even the citation contained in the complaint. Those objections become more damaging when the court file apparently lacks the notice to quit the plaintiff says exists. Did you notice how the judge repeatedly asks one narrow question while counsel keeps expanding the argument? That usually signals frustration and a credibility problem. Even a valid debt claim can be delayed or dismissed when the plaintiff cannot establish proper filing, notice, and service.
All right, well, then I would dismiss this case and let it be filed that way. But my only issue is that defendant's counsel is not indicating that possession is at issue. Or doesn't know, I guess is probably the best way to put it. So, what I'll do is
I
this.
can ask him, but I mean, and that's probably true because it's I don't know how long, he was there at all.
All right. Well, here's what I'm going to do. And I'm going to put this out to the 18th at 1 p.m. That's an in-person hearing. But it seems to me that if the issue of possession is not, if that's not an issue that he's voluntarily surrendered possession, then the matter needs to be filed as a general civil action. Because he's not in possession of the premises.
Your Honor, on the 18th, I have a mediation up north.
Well, since possession isn't so much an issue and we're basically at a fixed amount.
I will concede that it's not an issue and let her refile as a GC. I'll
But
stick
Your
it.
Honor, I just want to confirm one thing, Your Honor. At the time I filed it, Rhea still had possession. She was still living there, which gave Mr. Hammond access. It was only after she moved out and vacated the whole thing. At the time I filed it, he was on the lease and he was still coming over.
Okay, then where's the notice to quit?
I have it.
Okay, but it wasn't filed with, I don't see it with the pleadings.
This was, Your Honor, that one was way before I got involved. That was when Jason Negri was involved. And I have both of them. I've emailed them over to Miss Hammond.
Okay, but
if the court does, I wasn't the attorney of record on the case at this time, Your Honor. I'm happy to get a copy to you. It just wasn't.
I saw the notice to quit she sent me in the email, and it said it was signed by Wayne Docket that said that he personally served.
Okay, folks.
However, he was never.
Folks, if you guys want to just keep talking, that's fine. I'll leave. If you're saying to me that this was filed because he was in possession of the premises, then I would need to have a notice to quit. I don't have a notice to quit in the file. The complaint that's filed in this matter indicates that the defendant was basically served a notice to quit.
He was personally served a notice to quit. I personally served him the complaint to this hearing or to this matter. So I know he was served on that one. I personally served him.
That's fine. But if you're telling me he was in possession, but possession is no longer an issue, when did possession not become an issue?
Technically, when Miss Breeze moved out, because
what date?
She moved out February 28th.
Okay, so at the time that this complaint then is filed on March 17th, or at least signed on March 17th, possession isn't even questioned here.
At that point, she had surrendered it, but he was still on a lease that would have given him the right to reappear at any time.
That doesn't make any sense if you guys had the keys.
He has his own key. There were two keys issued, one to Mr. Hammond and one to Ms. Breeze.
Here's what I'm gonna do. I'll set this for an additional pretrial. I'm not gonna require you guys to do anything because you guys are just gonna want to fight about everything. April 25th, 2025 at what time? 2 p.m. That's an in-person hearing. We'll get it sorted out at that point. Thank you.
Thank
Your
you,
Honor, I so much apologize, but I have a site walk that day with another mediation client. What time did you say?
What time is it? It's at 2 p.m.
I think I can make that, but if I can't, could we adjourn? I mean, I think the site walk is in the
I'm
morning.
not gonna, counsel, that's not the way it's gonna have to work on this docket. I'm gonna set the date. I've given you said you couldn't do the
Yeah.
18th. I've given you the next date. That's
All right.
gonna be the date.
Judge Simpson does not decide whether the defendant owes the claimed $4,500, and he does not enter a possession judgment. Instead, he schedules an in-person pretrial because the record is too confused to support a clean ruling. The plaintiff says the defendant remained liable under a joint and several lease and retained a key, while the defense says possession was surrendered, service was defective, the notice to quit was never properly received, and the case should be treated as a money damages action. The timeline is especially important. The other occupant reportedly moved out on February 28th, while the complaint was signed in March. That raises the judge's core question. If possession was no longer disputed when the case was filed, why was this brought as a summary landlord-tenant matter rather than a general civil claim? The broader lesson is that having a potentially valid claim is not enough. A party must choose the correct procedure, preserve required notices, prove service, and answer the judge's question directly. The plaintiff may still pursue unpaid rent, but procedural confusion can create delay, expense, and credibility concerns. The defense has preserved multiple issues but will still need evidence supporting its service objections, counterclaim, and position on possession. Who do you think has the stronger argument going into the next pretrial? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.